SJC-13712, Jeff Stacy versus Unitil Corporation et al.
Okay, Attorney Caniff, whenever you're ready. Take your time. Whenever you're ready, but take your time.
Thank you very much. May it please the Court, Chief Justice and other members of the, associate members of the Supreme Judicial Court. My name is John Caniff. I'm accompanied today by my colleague, Robert Martin, and I'm here today on behalf of the Travelers Insurance Company in the matter concerning Stacy versus the Unitil Corporation. As I'm sure you're well aware, this is a workers' compensation matter, and although the Unitil Corporation did have coverage, I basically represent Travelers Insurance. I'd like to thank the court, and specifically whomever was kind enough to, sua sponte, reach down and grab this one from the appeals court. It's not often that a workers' compensation matter reaches the lofty heights here at the SJC. And secondly, I'd like to thank the court for giving us a roadmap for the issues that are being presented here today, notably in the request for amicus briefs, and I know that there was an amicus brief filed in this matter. Why are we here today? We're here today basically because we believe there was an error in the determination of a question of fact. Question of fact being, did the employee, and if I may, I will adhere to the nomenclature of employee, insurer, and employer rather than appellant, appellee, et cetera. It's just easier to understand the context in the players in this case. Was there an error in the determination of a question of fact? That calculus comes from Perron's case, 1949. It was the first time that the then added first sentence to section 17A of chapter 152 regarding a personal injury that stems from a infectious or contagious disease was considered. And the calculus was such that under those set of circumstances where...
Why don't you focus on the exact language? Because I don't know if it's a question of fact or a meaning of the statutory language. So why don't you keep reading, stemming from an infectious injury, why don't you keep going, read the rest of the relevant statutory language.
The relevant includes infectious or contagious diseases if the nature of the employment is such that the hazard of contracting such diseases by an employee is inherent in the employment.
Right. So, okay, that's what we got to answer. I don't know if that's so much a question of fact as a question of law, right? The nature of the employment such that the hazard is whatever the language is, right?
Yes, Your Honor.
Okay, so you're, in COVID, you read that, I take it to be limited to the doctors and nurses, or is that your...
I would say individuals whose employment brings them in direct contact with the infectious disease.
But so there's a second question whether this is an essential employee at the time he gets COVID, but he's an essential employee. Those people are placed at much greater risk while the rest of us are at home, working from home on Zoom. So doesn't he meet the definition of that statutory language by being an essential employee? If he's an essential employee, I understand there's a second question, but why don't you address the first one? Because I have trouble thinking that someone who's performing an essential task for the state during this COVID crisis isn't being put in harm's way here, the way the statute describes.
Well, Your Honor, the second half of the question is, was he indeed essential at the time? And I can get there.
Save that. Why don't you answer the first question? Because if you win on the first question, we don't have to answer that question, right?
Well, Your Honor, if one understands the actual chronology and facts of this case, the essential services designation or essential workforce, it's not particular to the employee, it's particular to the industry. There were 14 basic economic categories of employments that were designated essential. But after June 8th, when there was a reopening,
So if he had contracted COVID in March 2020, your position would be, yes, this was inherent in the nature of his employment that he got this personal injury, or?
no, Your Honor, I
Okay,
would,
why not? What if he had gotten COVID in March 2020 when he was among the few people in the Commonwealth who were required or allowed even to go out to perform their job? Why would he not fall
Because
within the
the,
definition of personal injury at that time?
there's nothing to say that he would have been exposed to COVID directly because of his employment.
Well, I think that what is inherent in his employment, I think the essential work services piece is a little bit of a red herring. What is inherent in this man's job is that he is required to be in contact with other people. He has to go to job sites. He cannot do unlike people who can do their job from a computer and could work remotely, an inherent aspect of his employment is that he has to be there in person. And so that put him at risk to a degree that's different from other essential workers who also were required to report to work but could do so remotely. Is that not true? Why is that not inherent in his employment?
The nature of the employment is that under ordinary circumstances, this individual would not be exposed to any infectious or contagious
Right, which is
diseases.
why I asked you to assume, for the sake of this particular oral argument, that he had not, in January 2019, but in March 2020, when there was an emergency declared and everybody was sent home except for him and his coworkers and other essential workers. Why wouldn't that be inherent in his employment that he would be exposed to this infectious disease?
Your Honor, the possibility of him being exposed to the contagion was not contingent upon the dates that he was an essential worker.
Is it the legislative history that we look, is it the legislative history that we look at to help guide us in what inherent in the employment means? As I read the brief, and it occurred to me that it, was more geared towards tuberculosis outbreaks and the like.
Yes, Your Honor.
Is that what we look to, the legislative history, or are there cases that guide us in this area?
Well, no, actually, Your Honor, there's very few cases.
Right, that's
there
the
was,
problem. There's some out-of-state cases that help you, but as far as this statute goes in the legislative history, can you help me out as to how we're supposed to use those tools to interpret this statute?
Well, Your Honor, we only have about 5 cases in this since the the first sentence of Section 17A was put into place in 1942.
But what about any legislative history? Do you have any of that?
I'm not familiar with it, Your Honor, in that regard. What I will say is this, that I believe that the fact finder in this case, the administrative judge, used the word essential workforce or essential services as the equivalent of essentially characteristic. And now that's an entire misuse and misapplication of one term for another.
But, a judgment call is made that certain people are going to have to be exposed to COVID to keep the rest of us safe and operational. And those people are going to have to go to work. It's not like tuberculosis where, we're all sort of have the same type of exposure except for the doctors. this group of people was put in harm's way because of their jobs. I just, and it seems to me hard to ignore that.
Well, that's hypothetical, Your Honor, that he
No,
was.
it's not hypothetical. We all know that they had to go to work and were exposed to COVID at a time when people were getting sick. And the rest of us were told to stay home so that we wouldn't spread this anymore.
But the facts of this case don't express that hypothetical situation, Your Honor.
But it does, because this isn't a situation where there was a category of essential worker that was allowed to go back and do their work in silos. Going back to Justice Dewar's point, the record indicates that the way this particular essential occupation worked is they all gathered somewhere, and they were all given assignments, and they were all in congregate settings, and then they broke out into one and two, I think, two-person trucks, and they went out to do whatever they did. So this is a situation where, and I got to marry 2 points here, because okay, in a conceptual world, the linemen that do this electrical work do not have as an inherent part of the nuts and bolts of the job potentially exposure to COVID. But if you focus on Justice Wendland's point, this is not just in the conceptual world. This is in the middle of COVID. So now they're in March of 2020. There's this contagious disease out. They're in a congregate setting because that's how they work, and they have to do this because they're essential employees. Why is the decision of the judge in this case, and that was affirmed, how is that wrong? I just don't.
But the essential status did not, may have existed in May of 2020, Your Honor, but it did not exist after June of 2020.
Well,
That was my question, so assuming what you just said is true, when did this particular individual contract COVID?
February of 2021, Your Honor.
And by then, what had reopened?
Phases, there were
Phase
4
1 and
phases.
2?
Phases 1, 2, and 3.
Okay, so 3 phases. So now, the question is it, while not entirely normalized, now the nature of his employment at this time, was it such that he would contract the infectious disease?
Well, the nature of his employment at the time that he contracted the disease was the equivalent to all the other open businesses.
Phase
which-
1 through 3.
Phases 1 through 3. He was on that same status.
Right, so if we say that for him, the nature of his employment at that time falls within the personal injury definition, then the same might be true for all the phase 1, 2, and 3, so long as they worked in some sort of congregate, more than one person setting, right?
Are you saying that they too would have been?
Right, if the administrative judge's decision stands here, there's no reason why it wouldn't apply to all employees in phases 1, 2, and 3.
Well, Your Honor, that's the reason why there's a specific restriction for an infectious or contagious disease in the first sentence of Section 17A. Everyone, under normal situations, irrespective of the COVID epidemic, is subject to, in the general population, possible infection from a contagion. Think measles. Had this individual been subject to measles at any point in time during this time frame, we certainly would not have considered his employment to be essentially characteristic of an exposure to measles.
Can I ask you what the standard of review is here, and in particular, does the board here get any deference in its interpretation of the statute?
As I said in my brief, Your Honor, this is interpretation of the statute, and that's deferred. That responsibility is left to the courts, not to the Industrial Accident Reviewing Board, which is an administrative body.
So you're saying they do not get any deference in interpreting the statute that they administer?
With respect to their experience, Your Honor, they do, I would say, get half a step up with respect to,
They're a specialized agency with expertise in this area.
yes, but they don't have expertise in interpreting the operation and the beginning and end dates of governor's orders.
It's the interpretation of the words of the statute which we're looking at, not, we don't owe them deference as to the interpretation of the words of the statute, correct?
Well, they've only had the opportunity to decide the words of this statute 3 times before, Your Honor. Actually, 4. But
That was a question to help you out.
Yeah. And I think Justice Wendland's was too. Can I follow up just on her question? So I don't read him as not being essential in June or whatever the later date, but he's not different from a huge number of other people at that point. He's essential, but a lot of people are at least permitted to go to work. He still remains. Is there something in that order by the governor that says he's no longer essential? Because the way those orders were done, they could just pop up again at any time. So I thought he's remained an essential employee. It's just many more people were now allowed to go to work.
Your Honor, I would state to you that Order 37 is plain and unambiguous.
Tell me the sentence that says he's no longer an essential employee. What do you rely on for that? Because I've read it a couple of times. I'm not sure what you're turning to.
Order 37, page 7, COVID Order number 13 is rescinded effective 12:01 a.m. on June 8th, 2020. And I believe that's found at Record Appendix 1, page 129.
So even though there are all kinds of things still in place, for that order to make sense, lots of the old restrictions are still working, right? It's not as if this order, you can interpret 37 without the earlier one. They don't work together without a lot of the first order remaining in effect, right? Because you don't know who's...
Your Honor,
let me simplify the question. Is that Order 37 self-explanatory and self-executing by itself, or do you need to keep parts of the earlier order in place for the whole thing to make any sense?
the order you need to keep in mind when you're interpreting 37 is actually Order number 33. It was not part of the original hearing record, but Order number 33 specifically stated that it was about to supersede. It foretold a change in the implementation of the phasing in of openings. And what happened in that case, it indicated that essential businesses, of which there was the 14 categories, was being folded into those categories that were being allowed to open under Phase 1. And those essential employments designated in the category of essential employments were going to have to comply with the same opening restrictions that were being placed on those employments in Phase 1. However, the term essential workforce or employments was completely eliminated when Order number 13 was rescinded by 37. And what's very confusing in this case is that we have all these governor's orders. There's 1 through 69, 69 being the one that finally ended the declaration of emergency. And then we have all these dates that are contained within all of these orders. And lastly, we have these phases, 1, 2, 3, and 4. And the last phase, which was not opened at the time, included amusement halls and Six Flags and ventures of that nature. And what's interesting here, there's an Index A to both 13 and to 37 that indicate which businesses are in which phase. And it says specifically in Table A of 13 which ones are essential businesses. Table A to Section 13 states specifically what is contained in Phase 1. And it says at that point, in the first line, that those businesses which were previously designated as essential were being folded into Phase 1 and subject to the requirements of reopening that everyone else was being imposed to. At that point, I would say to you, you take the word rescinded and you take the fact that other businesses are being allowed into the workforce, the threat of contracting COVID was the same as it was to any other worker at that point in time.
Okay, thank you very much.
Thank you very much, Your Honors.
Okay, Attorney McKenna.
Your Honor, Joe McKenna here on behalf of Mr. Jeff Stacy. The issue in this case is really the definition of infectious disease. And it's an expansive one, although we have cases that do with TB or are in medical sections. There's no restriction in terms of the language. In fact, the language is broad. They don't talk about particular jobs. They talk about the nature of employment.
Any legislative history, Mr. McKenna?
I am not aware of it, Your Honor. Okay. But they talk about the nature of employment, which is expansive. They talk about what's inherent in the employment. So it allows for a multitude of applications. And it's up, as Perone's case tells us, it's up for the trier of fact to determine whether the infectious disease was.
The traditional ones, though, are, okay, you work at a dry cleaner and you're exposed to all those chemicals, it increases your chances of getting cancer. Or you're a doctor or a nurse and you're exposed to, terrible diseases like Ebola or whatever. This is sort of a in-between category, right?
Well,
and it
I
doesn't
think
cover
it's
if you get the flu at work or, right? If he got you sick today, that wouldn't cover that, right? It has to be something different, right?
Well, it's, I think, time, place, and manner. I mean, we have to remember this was a worldwide pandemic. Millions of people had died. The governor essentially shut down the Commonwealth.
But everyone, like, if I'd gotten COVID, I wouldn't, at my house, I wouldn't be covered, right?
No, and there's also the obligation to prove causal relationship. That's never gone away.
But just stick to, I think you gotta walk us through, because they're two very difficult issues. Does he come within this definition because he's an essential employee? And then secondly, is he an essential employee when he actually gets sick? So I'd try to answer those two questions if you can, because I'm struggling with both of those.
Certainly. As the beginning of the executive order, which the judge, I think, leans on as proof of where to pass out who had to work and who perhaps was optional at some point in time, there were certain professions that had to work in order to sustain the health and safety of the citizens. We needed our food delivered, we needed our lights on, we needed our houses heated. So those individuals were required to go out, and unlike you or me, that perhaps we can do our job on a laptop in our house, they had to go out, and in the words of the trial judge, work shoulder to shoulder with each other. They were a different category. A line goes down, you need to mount the pole, you need to string the lines up, you need a bunch of guys working together.
But
So
danger,
fast forward to February 2021.
The conditions, I would argue, had not changed. We had just seen the introduction of a vaccine which was available to doctors, not to workers. It wasn't until April that the vaccine first became available to workers, and eventually by the end of May, June, we have the
But what do we
goalposts.
do with, and I'll check, but maybe you can just confirm, phase 1, 2, and 3 had been reopened?
They had, but it was a permissive reopening, as opposed to the essential workers. They always had to go out from day one to do the job, and we relied upon them. And what is permissive as opposed to what is required is a different story. You may have elected to go into the office. These guys had no choice, and they had no choice from day
And
one.
that affects the nature of the employment? Is that, I mean, I'm just trying to
Yes,
tie it back to
yeah,
the statute.
yeah. It's the nature of the employment. They had a different nature of the employment, and they were called upon to actually work together in the face of a violent pandemic in ways that other people did not necessarily have to do.
It's a bit remote, because the nature of the employment that causes the infection in this case is pretty much the ride to the job, correct?
Well, no, it's the working with the guys as well. I mean, it
They're working
so
out.
happened that on the ride to a job to get tested after it had started going through the workers, the coworker turned to Mr. Stacy and said, geez, I haven't been feeling well for a couple of days. Maybe I should ride alone. And he aptly said, well, I think it's too late now, and it was. What's not on the record is the boss told the coworker to come into work on Monday, even though he wasn't feeling well, because guys were dropping like flies.
I'm just trying to get the nature of the employment and how that's inherent in it, and it's obviously easier with a medical professional.
Right. Well, I'll give
versus-
you another example. HVAC, you don't assume that's an inherent risk for COVID, but what if you're tasked with making hospital rooms negative pressure rooms, and there are COVID patients in them, and boom, you contract COVID? I think you have to consider the time, place, and manner. And that case actually existed. The fellow got very sick. He was in Mass General for 2 extended times. Thankfully, he got better. But the whole nature of work changed.
Can I
The
ask,
whole nature
can
of
I ask a
employment
follow-up on
changed.
Justice Wendland's question? Say, okay, we're in phase 2, 3, and 5, or whatever. 2, 3, and 4 have to go back to work. It's permissive, you say, but your boss says you got to come to work. Are all those people eligible for workers' comp because they were required to come to work by their employer?
Well, there were also distancing requirements and everything else. So I don't know that they would necessarily fall into the same category. And the law says it's up to the trier of fact to determine whether the nature of the employment caused an inherent risk. And I think in this situation, you have the trier of fact doing that, and the reviewing board agreeing with the analysis.
Can I ask, I have a hypothetical for you. It is the following. So COVID was circulating pretty freely before even the initial declaration of a state of emergency. We had the Biogen conference, for example. If your client had contracted COVID on the same facts, in other words, it's undisputed, he got it at work, before the state of emergency was declared, how would your argument work in terms of saying that that risk or hazard was inherent in the nature of his employment?
What I would say is it always comes back to the law and the particular facts. The declaration and the end of COVID are goalposts. They allow for an easy beginning.
So
and
your
end.
client would be out in the cold in terms of coverage if the infection had occurred on the same factual circumstances
Your Honor,
before?
not necessarily so.
Oh, I'm trying to find that out. So if it had happened before the declaration of emergency, so that before that he was designated as working in an essential service, how would his contracting COVID during that period, even if it was undisputed that it occurred at work from one of his coworkers, how would that be inherent in the nature of his employment?
It would have to take a pretty extraordinary set of facts.
Okay, so as I understand it, because I'm just trying to get to the nub of where your argument lies, is it all turns on the status of the various governor's orders.
Governor's orders are instructive. They gave the judge an easy way to categorize this guy being an essential worker, that he needed to go out when, candidly, most of us were at home. He had to go out, he had to work side by side with other fellows to keep the Commonwealth safe.
Sure, I understand. So if, I'm just trying to always tie it back to statutory interpretation. So I think what your argument is, but please correct me, is that by virtue of the designation of an essential service, the governor was also, essentially as a matter of law, saying that the risk of contracting an infectious disease was inherent in that person's employment.
Yes. Those are the people that had to go out in the face of the pandemic. So their work was, by its nature, going outside and being with one another, inherently dangerous. And that was limited to a subset of
So
people.
then that becomes, it becomes dependent upon the reopening, because, you know, many of these orders say things like in the preamble, the risk of contagion has dropped a lot. How do we, so are we supposed to take all of the stuff that's in the various executive orders and import that into the definition of inherent in the employment for purposes of the statute?
No, Your Honor. I think that at the beginning, there was a designation of who we needed to go out and keep us safe, doctors, medical staff, et cetera. That never changed throughout the pandemic. There was no executive order that says, oh, you know, you can go home and work remotely. And of course, certain jobs can't be done remotely, and people have to put themselves at risk. And we elevated those workers, and they did their job. The grocery store workers making $10, $15 an hour, they risked infection and death. So did the utility workers and other workers. So I'm saying in the space of a worldwide pandemic, in an extraordinarily virulent situation where these guys lacked a lot of the proper PPEs, they were last to get infections along with the rest of us, that we should at least acknowledge during this time frame that the nature of their job, being out in the public, working with each other, exposed them to an inherent risk that was not part of the population at large. Candidly, they kept us safe.
I appreciate all of that, but I think it needs to be tied to the language of the statute, correct? If it was after the state of emergency had terminated and there were no such things as the phases anymore, it's just back to normal. And a lineman in similar circumstances got COVID from a coworker, I take it you would agree that that person would not fall within the definition of personal injury for purposes of the workers' compensation statute.
Most likely not.
And right, and so before, and just to go back to my hypothetical, your position, I take it, would be the same if it was before the initial declaration of state of emergency.
Your Honor, I find myself hard-pressed to admit that someone that got COVID one day before the state of emergency would be discounted. But there is a certain logic in the start and finish line marked out by the governor, so perhaps
It seems to
we
me
have
the
to
only logic you have, because you're depending upon those orders to give meaning to the definition of personal injury. Because if you don't have, if there had never been any executive orders, could you point to anything in his work as a lineman that would have said that the nature of the employment is such that the hazard is inherent in that work?
Not in the job itself,
Right.
but I would remind the court that the jobs...
If your client is not covered by this workers' compensation insurance, what recourse does he have?
Social Security disability.
Okay, thank you.
Can I ask one other question? So your brother argues the last sentence of Order 37, COVID-19 Order number 13 is rescinded. And then I think he cross-references the fact that earlier in this order, I issued COVID Order 19, which designated certain COVID-19 essential services. So he says, okay, I read that, meaning the essential service designation goes away. I'm not sure that's right, but I don't have I look at the next clause, whereas on March 30th, I issued COVID-19 orders 21, 30, and 32, which extended the period in which COVID order number 13 would continue to restrict essential service, that do not provide essential services. So we don't have 21, 30, and 32 in our record. Do they provide for essentials? Do they classify your client as an essential service in those two?
Your Honor, I'm not aware that they even address it. And my understanding as the orders as they went forward were more directed, as a reviewing board pointed out in its decision, to a gradual allowance of other brick and mortar facilities to open under very rigid circumstances. I don't think there was any express order saying, you folks are no longer essential, we no longer need you. And the reality is we very much did need them and very much rely upon them during this time. And again, I think it's up for the finder of fact to determine whether this gentleman faced an inherent risk of infection. Yes, he hung his hat on the executive orders, and I think that provides quite a good bit of cover, but he actually independently said he had to work facing a virulent risk of infection, and he made the findings that he fulfilled the definition. So at a bare minimum, I don't think there's enough to disturb his findings, but obviously I would hope that the court would extend coverage to similarly situated individuals. And again, we're talking of a fairly limited time frame. It's, you know, unless we face another global pandemic. But, you know, at the least, I would ask that you look out for those who look out for us.